Right, so in the interest of starting punctually, as one would expect in Switzerland, I would like to welcome you all to this workshop conducted by humanrights.ch. My name is Katja Achermann. I am a member of the focal point for strategic humanrights.ch. And I'm also a postdoctoral research fellow in international human rights law at the University of Fribourg, as well as an attorney at law here in Switzerland. Before beginning the workshop, I just want to make a few technical remarks and then a couple of observations on human rights' focal point for strategic litigation. So on the technical issues, we have, after the presentation today, a Q&A session. You can ask your questions either by typing them in the chat or by unmuting themselves. Unmuting yourself if you feel comfortable with that. That being said, we are recording this meeting. However, we will turn the recording off as soon as someone decides to ask a question or to intervene in the workshop for privacy and data protection reasons. Right, now on the focal point for strategic litigation of human rights.ch. So the aim of the focal point is to establish and popularize the instrument of strategic litigation to protect the human rights in Switzerland. The focal point that we have sought to establish over the past 3 years or so does not thereby litigate cases itself. It rather accompanies and supports a selected number of cases in their strategic efforts. And so what the focal point for strategic litigation really does is sort of to help lawyers and other representatives in a particular case to develop their strategy, but also with their communication. Other than that, the past 3 years have, been characterized by an effort to really build a network of relevant actors within Switzerland, coordinate this network of relevant actors, but also to build the knowledge and the capacity to litigate cases strategically in Switzerland. And for that purposes, we on the one hand conduct workshops and conferences such as this workshop today, but we have also drafted tutorials which are uploaded and available on our website that we call how-to tutorials. So we have uploaded a how-to European Court of Human Rights tutorial, which sort of in a fair amount of detail, but also with helpful links to further information, elaborates on how you can bring a case before the European Court of Human Rights. And we intend to upload actually in the next couple of days a similar tutorial for UN mechanisms, that is for UN treaty bodies, but also for UN special procedures. Right, and so as part of this effort to build the knowledge and the capacity to litigate strategically in Switzerland and beyond, we are very happy and grateful to welcome Boris Wijkström today. Boris is the founder and was the director of the Centre Suisse pour la Défense des Droits des Migrants. In this capacity, he brought many cases relating in particular to migration and asylum before UN treaty bodies, and brought such cases to the attention of UN special procedures. As of November 1st of this year, Boris has taken up a position at Caritas, and at Caritas, Boris heads the focal point for strategic litigation and continues his work in that capacity. Boris has studied for his BA at Stanford University in the US and has obtained his JD, so his law degree in the US at George Washington University Law School. He was subsequently admitted to the bar he was subsequently admitted to the Columbia Bar in Washington, D.C. and has subsequently worked as an attorney at law, both in the US, but also in Switzerland, namely for the International Organization for Migration and the World Organization Against Torture. So without further ado, I would like to hand over to Boris Wijkström, who will be speaking about admissibility criteria in particular before UN human rights treaty bodies. Thank you very much for being here, Boris, and I very much look forward to your presentation and the workshop. Thank you.
Thank you very much, Katja, for that presentation, and also to Human Rights.ch for the invitation to come and talk to you about admissibility before UN treaty bodies, some common issues before the Committee Against Torture and the Committee on the Rights of the Child. Katja, as you correctly said, I am now, when I accepted the invitation, I was the director of the CSDM. I just wanted to add that that organization doesn't exist anymore, and the activities of the CSDM have actually been taken over completely by Caritas, including the pending cases that we had there. And now I am now the focal point for international litigation at Caritas. I will be talking about admissibility issues by discussing a case scenario that I have cobbled together from what I consider typical facts that I see very, very frequently occurring in my practice. You should feel free, and anyone should feel free to interrupt me if they have questions or require clarification about things that I have said. I generally do not provide any legal advice on specific cases that are currently pending, though, before either the national bodies or international bodies. That's my one limitation. Okay, I think I will move ahead with a slide, my first slide. We will be talking about admissibility. This is one of the main challenges that confront anybody who is doing international litigation in any area. And it has to do with the fact that the international system is, as you all know, subsidiary to the national system. When a nation state signs a convention, a human rights convention, for instance, they agree to organizing their legal system and their society such that the rights enshrined in the convention are effectively applied. And so before being dragged before an international jurisdiction, certain criteria to answer for a supposed violation of the rights enshrined in a particular convention, a rather long list of criteria must be satisfied. And admissibility criteria, that is, and I will be focusing the presentation on two of them, which I think are very common obstacles. The first one is lack of exhaustion of remedies and insufficiently substantiated complaints. And one introductory comment that I wanted to make, and that I have spoken in the few moments before we started here with Katja, is that the practice of the international institutions, the international bodies in the area of admissibility is somewhat of a moving target. That is, the jurisprudence on admissibility is something which is in constant evolution. It's developing, and UN treaty bodies are continuing to draw the line in what they consider to be an admissible complaint or not. And so I'm speaking from my limited perspective, my limited experience, but I would be very happy to also to hear from others on how they would tackle some of the admissibility challenges that I'm going to talk about now in this presentation. I normally don't have canned answers. That is, I will present you with challenges and problems in the admissibility area, some of which we have successfully dealt with in our practice, my practice at the CSDM. And I can talk about the approaches that we have taken, but often, since, as I mentioned, it's a moving target, what you have in this area are not necessarily right and wrong answers, but what you will have is convincing and less convincing arguments. And I would be very pleased to share with those of you who have experience in this area to hear how you have dealt with some of these challenges. Okay, I will go over to my next slide. Yeah, that's the one. So when talking about admissibility, one thing to keep in mind is that there is the rule, but there is also the exceptions, and exceptions sometimes become extremely important. I will illustrate why. The exceptions can be derived directly from the optional protocol number 3 on the individual complaints procedures. I'm sorry, I'm talking here about the Committee on the Rights of the Child, the optional protocol to the Convention on the Rights of the Child, Article 7, but as an example. So there are some written exceptions, but there are also exceptions that have been developed in the jurisprudence of these bodies. If I could go on to the next slide. So on the next slide, on this one, I'm illustrating, actually, no, the one, yeah, that one. I'm just illustrating one of the most relevant stages of the proceedings where admissibility issues come up. You have their complaint. If you are lucky, your complaint is registered and is forwarded to the state party. And then what happens is that the state party is requested to submit observations on your complaint, and then which are transmitted to the treaty body. And then the treaty body will transmit those observations to you as the representative. And the first thing that the state party is going to say, naturally, in terms of their reaction, is that your complaint is inadmissible for a number of different reasons. And that's normally where you will have encountered these reasoned challenges to the admissibility of your complaint. Of course, it could happen before then as well, because the committee, the UN treaty bodies, when you submit a complaint to the petitions unit, you might, in the worst of cases, get the reply that the treaty body has decided not to register your complaint. And normally that answer is not reasoned, so you will not actually know the reason why the complaint is not being registered. This is one big frustration actually with treaty body litigation, is that when the complaint is not registered, you will not necessarily know why. we have also tried to, when that has happened to us, we have tried to get a more reasoned decision from the committee, but without any good results. The committee usually just answers saying that all of the facts and arguments were considered by the Special Rapporteur on New Communications, who decided that the complaint cannot be registered. And so there is no further motivation given. However, in the observations provided by the state party, there you will see a lot of reasoning which you will have to challenge. If we go over to the following slide, okay, this is an example of how not to present slides, because there is too much text on it. And I did this on purpose, and it's just an illustration of the fact that there are many different criteria that you will have to satisfy before a complaint can be deemed admissible. And on this slide, we see that there are 8. So I will just go over them very, very quickly. And this slide, as I said before, this example of the rules is taken from the optional protocol number 3 to the CRC, and it's phrased negatively. So a communication is inadmissible when the communication is anonymous, it is not in writing, the communication constitutes an abuse of the right of submission. The same matter has already been examined by the committee, or has been or is being examined by another procedure of international investigation or settlement. All available domestic remedies have not been exhausted. This shall not be the rule where the application of the remedies is unreasonably prolonged or unlikely to bring effective relief. And there we see the first written exception to the rule. Then we go on to F. The communication is manifestly ill-founded or not sufficiently substantiated. This is one of the rules that I will be talking about more in detail later. And it's important to note that not sufficiently substantiated, substantiation refers not just to the proof that the applicant or the complainant will provide, but also to his argumentation. So an argument itself has to be developed. It's not sufficient merely to say that a certain argument has been, a certain article has been violated. You have to actually reason why that argument has been violated and then provide the evidence for the violation. Continuing then to G, 7G, the facts that are the subject of the communication occurred prior to the entry into force of the present protocol for the state party concerned, unless those facts continued after that date. So here we have another exception. In the context of the Convention on the Rights of the Child, sometimes commentators have asked themselves the question, if the child's rights were violated while the child was a child, a minor, and then the consequences of that violation continue after the child becomes an adult, and they were never addressed, and it's only after the child becomes an adult that they're able actually to complain about the violation. Would the convention apply? This is a related question to that. Okay, now we're going over the last requirement here, H, 7H. The communication is not submitted within 1 year after the exhaustion of domestic remedies, except in cases where the author can demonstrate that it had not been possible to submit the communication within that time limit. So here we have also a written exception. Now, I'm going to talk about a factual scenario, and then I will, thank you, and then I will, I'm going to talk about this factual scenario which presents certain admissibility challenges which are very common. The factual scenario itself, the factual and legal scenario, I should say, is also very common, and it's based on situations with which I have seen in my practice at regular intervals. So this is actually quite a common situation. The facts in our scenario are as follows. We have, I receive in my practice an Iraqi woman with 3 children who are 14, 10, and 8. She has no professional qualifications. In fact, she's illiterate. She obtains subsidiary protection status in Croatia, where she has lived for 3 years. In Croatia, she experiences domestic violence at the hands of her partner, who abandons her. This domestic violence leaves her profoundly traumatized, as well as her 3 children who are witnesses to that. After she has been abandoned, she stays on for about 6 months in Croatia, but she has no means of subsistence. She's not able to work because she has minor children, and possibilities to work for someone in her situation are extremely reduced. She finds herself on the street, and at that point in time, she decides to come to Switzerland because in Switzerland, she has family members. In fact, she has very many family members who all are citizens or have some other type of permanent status, so B permits, C permits, etc. And these are her parents, and all of her many siblings are living in Switzerland since a long time. And because of her extreme vulnerability, she decides that she needs the help of her family members, and she comes to and she wants to make this trip to Switzerland. On her way, she's approached by a man from her country at the train station, who entices her to his apartment, and there she is raped over the course of 3 days. The children actually are witnesses to this violence, and she's only freed after she makes an earnest threat that she will jump from a window, and then she's let go. Finally, she makes it to Switzerland, where her parents, well, as I said, where her parents and siblings are living. We can turn to the next slide. And in Switzerland, she is diagnosed with suffering from post-traumatic stress, a complex post-traumatic stress disorder, severe depression, that she's a suicide risk, and that she requires specialized long-term treatment at the University Hospital in Geneva. Her medical doctors also attest to the fact that she needs a stable environment and family support, and these family support is essential for the success of her treatment. Her children's well-being also depends on her recovery, and it's essentially the same situation for the children. The children are still suffering gravely from the violence that they witnessed at home, the domestic violence, and also the rapes that took place. So they're suffering from post-traumatic stress disorder, and various forms of developmental retardation, slow acquisition of language, etc., and require basically specialized and long-term multidisciplinary treatment. And if I go on to the next slide, she is placed in proceedings in Switzerland aiming, the purpose of which are to expel her to Croatia under a readmission agreement with that country. As I mentioned, she has subsidiary protection status in Croatia. So according to the State Secretariat for Migration, the SEM, she does not risk expulsion from Croatia to Somalia. So there's no issue with the non-refoulement principle. In Croatia, she has the same rights to healthcare, housing, employment, and social assistance as Croatian citizens. And if she does not get the help she needs, she can always ask charitable associations or seek a remedy in the Croatian courts if she has problems. That's the position of the State Secretariat for Migration. Her case is appealed, and in the appeal, the lawyer invokes the fact that she and her family are extremely vulnerable. They have a very complex medical situation, which will take a long time to stabilize. Proceedings in Switzerland have already lasted 2.5 years. Children have started school and are integrating into society and are slowly getting better with the intensive treatment that they are receiving, which includes multidisciplinary approaches. It's not just the medical approach. The lawyer argues that there's a violation of Article 3 CRC because the expulsion is not in the best interests of the children. They need a stable situation. Their condition is improving with the measures applied in Switzerland. And the lawyer argues a violation of Article 3 ECHR, CAT Article 3 and 16, and CRC Article 3, in that in Croatia, they would face a situation of abject indigence incompatible with human dignity. I'm coming to the end now of the case scenario. The Federal Administrative Court says in summary that Croatia is bound by relevant European law. There's no evidence that the family would confront a situation incompatible with human dignity, so there's no issue under Article 3 ECHR as it was interpreted quite narrowly in MSS versus Belgium and Greece. And furthermore, that the appellants, the family's medical situation is not serious enough to rise to the level of the Paposhvili standard by causing intense suffering and or a significant reduction in life expectancy as a result of the expulsion. Okay, thirdly, the Federal Administrative Court recalls that for Article 8, right to respect for family life, to apply outside the relations of a nuclear family, you need to prove a special relationship of dependence, which is quite an exceptional situation where you are essentially showing that without the assistance of the family member, the person would not be able to survive in dignity. So a very narrow interpretation. So why I have, if we go to the next slide, this, in a sense, this is a very typical scenario because, at least for 3 reasons, because the lawyer's arguments actually focus on the mother. The children's rights are subsidiary, and the entire, I would say that 90% of the argument, of the substantiated arguments, focus on the mother, not the children. The arguments invoke ECHR's narrow jurisprudence under Articles 3 and 8, as we just saw. And there's only one claim that is made under the Convention on the Rights of the Child, and that claim relates to Article 3, the safeguarding of the best interests of the children. Okay. Now this, thank you. Now this typical scenario, this what I just described to you now, the fact that the focus was entirely on the mother with the sole exception of the Article 3 claim for the children, is a problem for me, because I want to proceed with litigation before the Committee on the Rights of the Child. Okay, because in my opinion, the prospects of success for litigating a case like this are much, much, much better at the Committee on the Rights of the Child than, for instance, anywhere else, than, for instance, at the European Court of Human Rights. As we have seen, and as I will return to if I have the time in my presentation, the interpretations that the European Court has given in terms of the thresholds that have to be crossed for an Article 3 claim, Article 3 ECHR claim to be successful, are extremely narrow. So in a medical case, a medical Article 3 case, as we all know, there's the Paposhvili standard, which requires the Paposhvili versus Belgium standard of the ECHR, which requires that an expulsion result in the intense suffering of the person and a significant reduction in life expectancy. So essentially, if you want to sum up, the person basically has to be dying before an Article 3 claim in that situation could be successful. Secondly, Article 8 claims, well, she, in our case, our client here in this scenario, she has all her family in Switzerland. This is the reason why she came here, because she desperately needs their support. She has her parents and all her siblings, and she comes from an extended family with, let's say, hypothetically, 5 siblings, and they're all here, and they're all citizens or C permit holders. And the medical doctors have said that, well, she, in order for her to recover from the years of domestic violence that she has experienced and from the atrocious sexual violence that she experienced as well, she needs this stable social environment. At the European Court, I don't think that's going to cut it, because of what we saw in the previous slides, that you have to show a special relationship of dependency, which essentially means that your life depends on the care that the family member can provide you. And the typical example that's given in those situations is, for instance, in the situation where a person has a very severe handicap and relies on, let's say, their adult son or daughter to feed them daily, to clothe them, to help them take a shower, etc. And that if that person were expelled, if that adult son or daughter were expelled, you know, their parent would essentially risk dying. And so that's a very, very, very narrow interpretation. It's a very high hurdle to jump over. I think in this particular case, my client would not be able to jump over that hurdle. So I want to proceed before the Committee on the Rights of the Child, because there, as that committee's jurisprudence has illustrated, their notions of what private and family life are, of what the right to rehabilitation is, of what the non-refoulement prohibition entails, is much broader. It's much closer to what I think you and I would consider is the actual content of these rights. However, I have a big problem, because no child-specific right was ever raised in this case. And yeah, so how do I overcome this problem? if I want to proceed before the CRC. Let's look first at Article 12. I have outlined in purple there my favorite rights, if you will. Article 3, as I said, was invoked in proceedings as a procedural violation. The best interest of the child was not given sufficient consideration, the lawyer said, by either the SEM or the TAF, and that as a substantive right, it is not in their best interest to be expelled. And she submitted some evidence of that, including the medical records. So that claim has been exhausted. We don't have an exhaustion problem there. It has been substantiated with arguments and evidence. But let's look at Article 12, a child's right to be heard in all matters affecting him or her. This right was never invoked anywhere in national proceedings. And as I mentioned, these national proceedings, they took 2.5 years, even though it's a very simple, there's no legal it's not a legally complicated case. This is a person, we're talking about a person who has obtained subsidiary protection in another European country, and proceedings related to just having her readmitted to that country under an existing agreement. And so in a sense, there, like, you know, how do you argue, how can you justify that this very, very basic right of the child was never invoked? As many of you know, as all of you know, children are rights holders in and of themselves under the convention. And the committee has said in many different contexts that a child's situation has to be assessed separately from their parents' situation, especially in a migration context. Children might have reasons to oppose an expulsion, for instance, that are entirely separate and different from their parents. And since they are rights holders themselves, those reasons must be taken into account. And consequently, in our area, the child's right to be heard is very important, because expulsion is a matter which affects the child, no? But how do I get over this problem that it was never, this right was never actually invoked in proceedings? And the fact pattern that I'm giving you now has happened repeatedly, and is actually based on an actual case. And in this case on which the scenario is based, there's another factual squiggle which I have to tell you about, because it makes it even more dramatic, in a sense. The omission is that the mother, the Somalian mother, she actually left her first child in Somalia when that child was 4.5 years old. So she went in search of protection in Europe when her eldest child was 4.5 years old. And then she lost contact with that child. And en route to Europe, she met her partner, the author of the domestic violence, and had 2 children with him. And it was only when she got to Switzerland that she was reunited with her daughter, who had separately decided that she wanted to reunite with her family. And she knew that her family might be in Switzerland. And so this person actually, just by accident, the mother, just by accident, was reunited with her eldest daughter in Switzerland. But that also means that they were separated for, mother and daughter and eldest daughter were separated for approximately 8 years. And it is only now in Switzerland that they're getting to know each other. And then my question is, what happened actually to the daughter during her life and during her journey to reach Switzerland, because that in itself took a few years for her to reach Switzerland. What is her life story? Nobody knows, right? And it might be the case that the mother also doesn't know, because the mother is just now trying to get to know her daughter, and she has just met her for the first time after a very long separation. So in this particular case scenario, this child, the eldest child, is being expelled, and nobody has asked her if there's any reason which would actually that she opposes her expulsion. Okay, so I'm throwing out this question, and I actually have a canned answer for you, which I have used in other cases and which was successful. And this is probably actually, strangely enough, the easiest challenge to overcome, even though it seems like a very, very, very clear case of non-exhaustion. You know, you didn't raise it, you didn't give the Swiss authorities the possibility to redress this problem, and now you're arguing it at the international level. If we go to the next slide, you will have the arguments that I made in several cases, and one of those cases was MKAH. And I looked at the committee's jurisprudence in this area. You remember that I said that there is the rule and then there's the exception, and some of these exceptions are based on the jurisprudence of the committee. And the committee has said that the right of a child to be heard and taken seriously constitutes one of the fundamental values of the convention, and one of the 4 general principles of the convention, and that it should be considered in the interpretation and implementation of all other rights. Okay, and the fact that it should be considered in the interpretation and implementation of all other rights, it makes a lot of logical sense, because how, for instance, one of the other fundamental principles, the one that we most often think about, which relates to the best interest of the child, how, may I ask, do you determine the best interest of the child if you have not heard the child first, right? How is it possible to reach a conclusion as to what the best interest of a child is without giving them the possibility to give their views on the subject? And there, the committee has actually said specifically, and this is also in its general comment number 12, there can be no correct application of Article 3 if the components of Article 12 are not respected. Okay, so in a sense, when you have invoked Article 3, you have also invoked Article 12, because they go together. They are very, very tightly interlinked. Okay, and if we go to the next slide, there are several different cases that the Committee on the Rights of the Child has decided where it specifically says this. There's one, ZS and AS versus Switzerland, where the committee found a violation of Articles 3 and 12 because the state party failed to hold a direct hearing for KS. And so they have made this link directly. And if we go to the next slide, it just shows you graphically what I mean. These two rights are so interlinked that it's difficult to separate them. Just as an aside, it is amazing that even after the committee has found violations against Switzerland because of the failure to hear the child in migration and asylum proceedings on repeatedly. It is amazing that we practitioners, we continue to see these cases where the child has actually never been heard. So that is how I solved this first admissibility challenge in MKH, for instance. I looked at the jurisprudence. It's also entirely logical that these two rights are to be considered together. Yeah, I guess I'm doing fine for time so far. Okay, if we go to the next slide, this is a different admissibility hurdle. Rehabilitation, the right of a child to rehabilitation is one of my favorite rights, and I want to argue it in this case scenario that I've given you. And just so you know, in the case scenario, the representative of this family, she did talk about the medical needs of the family members and mentioned different measures taken by the school to help the children, because the children were suffering from, they were behind in their pedagogical level, and they needed different kinds of actually interventions by the school authorities, extra classes, etc. In addition to the medical treatment, the specialized family therapy, psychotherapy, etc. And she mentions, the representative mentioned this. The medical records also, I'm sorry, but the representative had never actually invoked Article 39 specifically, nor the concept of rehabilitation with respect to the children. So in national proceedings, nobody had ever said that actually, you know, these children have been subject to violence, and they have a right to rehabilitation, which is possible in Switzerland, but which would be at risk or not possible at all in the country to which they're being expelled. That argument had not been explicitly made, okay, in national proceedings. When I get the case, what I do is I contact the medical doctors immediately, and I say I need records for all of the children which attest to the follow-up that they're receiving on a medical level, but also to the fact that what they need goes, this is not just a medical situation, they need multidisciplinary measures which go well beyond that. They need social assistance, they need assistance in school, etc., etc. That this is a long-term process, and it requires very specialized services. Please, and I asked the doctors, please mention, if you feel that it's relevant and correct, that the stable social environment that the family members are providing the children constitutes a key element of their recovery. So in the absence of the stability of their social environment provided by the fact that their grandparents are present in their lives and can pick them up from school, and etc., and that they can play with cousins who speak their own language and have their own cultural frame of reference, in the absence of that, the medical measures have much less chance of success and maybe won't succeed at all. In fact, maybe they will not recover from their trauma at all. The basic requirement is the stable social environment. And I get those records and I submit them with my case to the committee on the rights of the child with my individual complaint. And of course, the state party, in their observations, they say, this is new evidence. This is evidence which no domestic organ has seen and has seen before, and it gives rise to in national law to a new remedy which you haven't used. The remedy is called a request for reconsideration, and consequently all your arguments about the need for rehabilitation of the children and the fact that they won't get it in Croatia are inadmissible, because you haven't first given the Swiss authorities the occasion to look at these arguments and look at the evidence. What do I do? It's a good argument from the part of the state. What do I do? How do I deal with that? As you will suspect, I do have an answer. If anybody wants to hazard an answer, you can interrupt me. Otherwise, I will just continue. Okay, I will try actually not just to overcome this obstacle, but to use this situation in my favor. And if we go on to the next slide, I will tell you what I do, what I have done. And others, of course, as well. The argument by the state party that I have not exhausted remedies because there's one that I haven't used and which is available to me in national proceedings, I take that as an invitation to submit a request for reconsideration with the Centre. So when I receive the observations, I immediately file a request for reconsideration with the Centre. And now we are in a situation where, as you can see on this slide, the complaint is ongoing. There has been a first set of observations in which admissibility was challenged on this basis for the rehabilitation claim. And then my response is that I engage in parallel national proceedings. And of course, I inform the committee that I have engaged in these parallel national proceedings, and I keep the committee abreast. And if my request for reconsideration is rejected, as it often is, then I inform the committee that, well, the state party now has had the possibility to review these arguments and to on the merits and to review the evidence, and they have rejected it. Therefore, I was right in the first place not to there are different ways of formulating it, but one way is to say that I was right in the first place not to invoke this remedy because there was no chance of success. But in any event, I did, and as you can see, it doesn't work because the state party takes an excessively narrow view of the rights enshrined in the Committee on the Rights of the Child. And so I try to use it to my advantage. The other possible outcome, and this was done in the MKAH case, which some of you might be familiar with. The other possible outcome of this situation is that the State Secretariat for Migration actually accepts the request for reconsideration. And that is excellent because then, in a sense, I have been able to solve the problem for the client and regularize their situation. And this has also happened in our cases. And it happens at this level of the exchange of observations, which is a very, very important stage of the proceedings, because it can lead to the solution of cases. So now I'll make a small aside. If we go to the next slide, I'll make a small aside on on the right to rehabilitation. As I mentioned, it's one of my favorite rights in the Convention on the Rights of the Child, and it's very underutilized and very, very often ignored. In the case scenario that I gave you, it's a right that basically it jumps off the page when you read the file and slaps you in the face. That's how obvious it is. And at the same time, this actually is the reaction of the TAF in this case scenario. And it's actually the text is in French, but as I mentioned, I'm surprised by the reaction of the TAF here in this case, because the representative actually never actually mentioned the word rehabilitation or Article 39 in connection with the children at all. However, the TAF seems to want to preempt any such argument anyway, and of its own motion, it says the following thing. And when it says it, I feel particularly concerned, or not targeted is not maybe the right word, but concerned. And it says, in effect, the applicant and her children do not need any urgent medical treatment or any medical treatment which is particularly specialized. Also, we should recall here that multidisciplinary measures, medical, educational, and social, which have as their aim the development of the child, do not constitute essential medical measures under prevailing jurisprudence. Okay, so this is the typical response of the Swiss authorities when you present them with a rehabilitation claim under Article 39 of the Convention on the Rights of the Child or Article 14 of the Convention Against Torture. They perceive this, or they mischaracterize this deliberately, maybe, if I may say so, as a purely medical claim. And in fact, it's not. But they characterize it as a medical claim because then they can invoke the very, very narrow interpretation of the European Court of Human Rights on medical cases that I mentioned before. So this is mischaracterized. This is not a medical claim. I am now talking about the rehabilitation of a child. And rehabilitation has one medical component, but it goes far beyond. And the fact that it goes far beyond, the Committee on the Rights of the Child has been explicit on this in one of its general comments. Unfortunately, I didn't include that slide in this presentation, but if anyone is interested, I can come up with a reference in one of its general comments. And the Committee Against Torture has a whole comment on the right to rehabilitation, and there it explains that this is not exclusively a medical question. This goes much, much beyond that. Here we're trying to, we're not just trying to make the person recover health-wise, but we're also trying to make them a full and participant member in society, okay? And so you cannot just apply this narrow medical optic to it. And this quote that I have on this slide is answered by the Committee on the Rights of the Child in the next slide. And this was in the context of the MKH case, and there the committee says, the committee also observes that the state party failed to take due account of MKH's status as a victim of armed conflict and an asylum seeker who allegedly suffered ill treatment during his stay in Bulgaria, and that it did not attempt an individualized assessment of the risk that MKA would face in Bulgaria by verifying how he and the author would be received, including in respect of, and here I underline in blue, access to education, employment, housing, medical care, and other services necessary for the child's physical and psychological recovery and reintegration. And on the following slide, we have Article 39, and there I have highlighted for you the words physical and psychological recovery and social reintegration. So this was taken directly out of the article on this quote from MKH, refer directly to the right to rehabilitation by using these words, physical and psychological recovery and social reintegration. Okay, I'm coming to my last question, or last admissibility hurdle. And this is also one of my favorite rights, if you will, the right to family life, because the Convention on the Rights of the Child has at Article 16 a disposition which is phrased in terms that are very similar to ECHR Article 8, and which guarantee the respect for a child's private and family life, and freedom from arbitrary interference with the child's private and family life. And now we come back to this problem that the representative in national proceedings, she did mention Article 8 ECHR, but she mentioned it mainly in relation to the mother, not to the children. She did say, however, in her appeal and the various correspondence that she exchanged with the TAF, that the relationship of her children with their cousins and grandparents and the medical records indicated that the extended family provided social stability, and the medical doctors had mentioned also in their reports, without elaborating, so without any substantiation, the medical reports had also said that, well, the presence of the children's cousins and aunts and uncles and grandparents is stabilizing and increases the chances of that therapy will be successful, and that a separation from the extended family is counterindicated. So my approach would be to the problem of the fact that nowhere in the record was specifically an Article 16 family life claim made with respect to the children. My approach would immediately be to say the rights were raised in substance. Okay, so because it's not necessary at all, in fact, sometimes it's not even advisable to raise rights specifically and name them specifically. Strategically, when you're on appeal or proceeding before the SEM, it might be better just to raise them in substance and hope that the national tribunals just don't even pay lip service to the rights. And if you mention them specifically, then they will be normally treated by the national instances, who will, and of course this is my own personal take on it, but who will give lip service to these rights and then make it appear as if they were taken into consideration correctly. But anyway, coming back to my approach to this problem of lack of exhaustion of this right, is I would say that, well, these different aspects of the appeal, it's partly the argument, which, true, it was not really substantiated, but it was made in different places in the appeal. There are some sentences from the medical reports that I can use. that I would say that, well, this was made in substance. One other approach that I would use is, and here here I would like to go directly to slide 25. Yeah. One other approach that I would use is, I would of course point out that the concept of family is completely different under the Convention on the Rights of the Child. And here we have, once again, the MKH case. And there, this quote is actually worth looking at in its entirety. Here the committee says, and I quote, the committee reiterates that family, as the word is used in the convention, refers to a variety of arrangements that can provide for young children's care, nurturance, and development, including nuclear family, the extended family, and other traditional and modern community-based arrangements. The committee is of the opinion that in the particular circumstances of this case, the separation of MKH from his cousins and uncle is likely to further hamper his development and social reintegration. And I underlined social reintegration because that is the terminology used in the Article 39. It's an aspect of the child's right to rehabilitation, social reintegration. So in this case, the committee continues, it says, the committee concludes that returning MKH to Bulgaria would therefore constitute arbitrary interference with his privacy in violation of his rights under Article 16 of the Convention. I think that the committee actually meant an arbitrary interference with his family life in violation of the Convention. I think that's reference to privacy is a kind of a typographical error because it's talking about family and just before. And this reasoning that I just read to you, it rings extremely relevant to the case scenario that I just gave you, doesn't it? So, and that should not be surprising because we have, my colleagues and I mainly, I mean, Gabriella Tau was with me litigating all of these cases, but we litigated several cases on rehabilitation before the Committee Against Torture. And all of these cases related to persons who had come to Switzerland because, so torture victims who were traumatized, because here in Switzerland, they had family members on whom they could rely for assistance. So there was actually, I can say with a great degree of confidence that there was never a torture victim that we represented on this question of rehabilitation that did not have family members here in Switzerland. And there, the Committee Against Torture in the case AN versus Switzerland recognized that that was kind of a key element of the complainant's reintegration was the proximity with his brother and the fact that that needed to be preserved, his brother who was here in Switzerland. So this is not, you know, and as I keep saying to my colleagues, people don't come here usually for the mountains and for the chocolate, etc. They traumatized people come here for this specific reason. And usually if you ask them, do you have family members here in Switzerland? Normally the reply is going to be yes, they do. So if we go on to the next slide, and that will, okay, so there we have graphically exposed the interlinked nature of the rights to respect for family life and the right to rehabilitation. And now my last comment is that interestingly, you know, in the MKH case, I was able to make the argument successfully, or it was me and my colleague Gabriela, that the mother's state of health could not be dissociated completely from her sons in that case, because if her state of health deteriorated, then that would obviously have a dramatic impact on her son, especially if it deteriorated after they were expelled back to Bulgaria. And so his rehabilitation, which was occurring in Switzerland, it could only be successful if her rehabilitation, which was also occurring in Switzerland, could also happen at the same time. And I would like to go to the next slide. And here the committee said that it was of the view that the mental health of the mother, the only person the child could turn to, his only caregiver, is essential to the child's harmonious development and survival. In this respect, it notes that the author does not speak Bulgarian, and she would find it very difficult to enter the local labor market and would have the wherewithal and would not have the wherewithal to obtain health services. So we were also able to link the state of health of the mother to the rights of the child, the possibility of the children to enjoy their rights. And that is the same in our case scenario, because in our case scenario, I don't recall if I mentioned this before, but the medical doctors had specifically said that if the mother was not able to continue with her treatment, for instance, in the case of expulsion or interruption of this treatment, that would affect her parental capabilities dramatically. And she would be going back actually to Croatia with 3 children. She came with 2 and she found her eldest daughter here. She would be going back with 3 children without any other support, so a single mother. And of course, that would have dramatic implications. And I love the way that the Committee on the Rights of the Child is able a little bit to think outside the box and to develop this quite rich jurisprudence on the right to recovery, the right to rehabilitation, on private and family life, etc. Develop notions that go well beyond these very narrow and restrictive notions that the European Court has developed in similar contexts. And I think I will end there. I have spoken more than what I intended, and I do want to allow some time for questions.
Wonderful. Thank you so much, Boris. This was hugely insightful. I personally have learned very much. So thank you very much for these elaborations.